It's been a while. We're back in the podcasting setup that we have, and we are literally going to hit the ground running. We have some very interesting, well, we think they're interesting anyway, interesting discussions to have over the course of the next few weeks, just to ease us into this this next set of podcasts. I've asked Ellis Sweetenham, one of our senior solicitors here, to join me. Ellis, how are you doing?
I'm very well, thank you. Mark, yourself?
Well, you always say I'm very well, thank you. How are you? You know, I always think, you know, when you pass someone in the street, you say, "How you doing? All right," and they always go, "Yeah, not bad." You?
Yeah, it's
you know,
the golden rule.
It is absolutely,
There's no
and then
other
walk
answer
on.
that's acceptable.
Yeah. I mean, to be fair, certainly for the purposes of podcasting, if I said "How are you?" and you just broke down into tears, that might put off our listeners. No. Well, anyway, thank you for joining me. I thought that the first one, just to ease us into it, should be something certainly from your perspective, which is bread and butter, incredibly important. Certainly, if you have a business, whether it's an established business, whether it's something that is just starting out, and that is the intellectual property for a business. Well, of course, I know you are the queen of IP, and I say official title, and I say IP or intellectual property, and most of our listeners say, well, what does that mean? Well, in actual fact, it's a very broad term. It's an umbrella term for lots of areas. So what I thought we could do is just have a general discussion over the basics. We won't bore everyone too much, but I'd then like to lean neatly on to the application within a business after you've just explained about the different points there. But I'll lead you into that. So fire away. So IP, what is it?
Intellectual property is probably something that most people know about without knowing about. So intellectual property, like you say, is an umbrella term and covers a number of different rights, both registered and unregistered. So trademarks and copyright and patents are the most well-known types of intellectual property. Copyright is automatic, so that's an unregistered right, and trademark and patents are registered rights, even though there is some unregistered elements in there, but we won't go too deep into that. But you've also got design rights, confidential information. There is quite a lot that is included within the umbrella of intellectual property, and ultimately it's those assets of a business that aren't real, they're not tangible, you can't touch them, but it's the know-how, it's the creative, it's the brand.
Okay, so if we just break that down then, so you mentioned about trademarks. So before we come into the application with a business, what is a trademark?
So a trademark is there to protect your brand, so your brand name, logo, slogan, product name. It enables you to ensure no one else can use a similar or identical brand in similar or identical goods and services. It's that bubble of protection around your brand identity to ensure that you have the power and the right to protect yourself from others, safe in the knowledge that you're building your own reputation and that's not going to be impacted by people popping up.
So give me an example just for our listeners. You know, pluck something as an example of something that would, you know, our listeners would be able to associate you with when it comes to trademarks. So
some of the most iconic trademarks, the Apple logo, that's protected by a trademark. All of the big brands that you can think of, they will have a trademark to protect their name and their logo. So Coca-Cola, Nike, Apple, Samsung, they all have multiple trademarks to protect themselves to ensure that I can't pop down the road and start Apple computers and impact them in any way. So any brand that has a distinctive name and or a distinctive logo should have a trademark to protect that and enable you to have a route through to prevent anyone else from starting any other name that's too similar.
We'll come on to that in a moment. So just going back to that point about the established brands, and it's recognisable, it's something that is capable of being protected. It's, you know, it's really distinctive. And I'm saying really distinctive, but, you know, it has to be, surely, to be able to, certainly in this day and age, after 100 and something odd years of all of this going on, with, you know, protecting rights and your trademark being your absolute must, or trademark protection, your absolute must for your brand to ensure that it doesn't get swallowed up by someone else that's got a bit more money and suddenly is able to just take over and suggest that it's theirs and it's always been theirs. But if you don't have something that's distinctive, explain to us what our listeners would be expected to do then. Do they just ignore? They don't need to try and protect it because it's not capable? Should they be changing their brand? That's confusing to me.
It all depends on how you want to grow and what your future plan is. If you are based in a small area, for example, we're currently recording this on our Isle of Wight office, there is many Isle of Wight businesses who have very descriptive names. Isle of Wight cheese, for example, does what it says on the tin. That's a brand that's quite local. People just need to know where it is and what it does. However, if you want to build a brand to success, if you want to build a brand that you can scale up, that you can sell on, you need to have an identity that draws you out from the crowd surrounding everyone else.
So is it about geographic location then, to a degree, that if you're going to start really pumping this out on the internet, all around the world, whatever it is, it will become distinctive? So when you go back to, you mentioned Isle of Wight cheese, is that something that through time, or certainly through its own identity, can then be capable of being trademarked, even if it's not something you would think about in the early days? Or do you think actually just go for it, just trademark the damn thing anyway?
So there is scope for brands to acquire distinctive character through use, but ultimately, ideally, you would start with a distinctive brand from the outset. Something that isn't related to your goods and services at all is, think of Kodak and cameras. It's one of the most famous brands in technology, and yet the word means nothing related to cameras. If you can identify yourself as the brand and you're standing out and it's not descriptive in relation to your goods and services, then get that trademarked ASAP, because what you're building there is a reputation. People recognise that brand as being you, rather than being a description of what you offer or where you are.
Okay.
It's about individuality. Is that the word?
Yeah.
I don't know if I said that right.
Okay, so that's fine. So that's trademarks. Just briefly, you mentioned about registered and unregistered, and those that are capable of being registered in some way, some database, and those that are unregistered. Mm-hmm. Unregistered, what does that even mean, the difference between registered and unregistered? And how would you apply that in the IP world?
So unregistered rights relate to rights that arise automatically. So as soon as a work is created, it is protected to some extent by an unregistered intellectual property right. So that's normally unregistered design rights or copyright.
Mm-hmm.
Unregistered rights will only take you so far. So for example, copyright, which arises automatically, while it can last for a very long time, you are only protected to prevent someone else from copying you. Registered rights normally have a wider reach, more of a monopoly right, provide you with a little bit more power. Copyright is one of those sorts of things that people fall back on as a tool to protect themselves against someone else that's popping up. So copyright, it is the most common unregistered right, and like I say, as soon as an original literary, dramatic, musical or artistic work is created, it is automatically protected by copyright.
So just say that again for our listeners, that list.
Literary, dramatic, artistic and musical works.
Right.
So that sounds like a lot of things, and it does, it covers a wide range, but it will only take you so far. And the important thing about copyright, it protects the expression of an idea, not the idea itself. So, for example, if I wrote my own book about a boy that discovered he was a wizard and spent his childhood living under the stairs, I could do that. However, if I ripped half of the Harry Potter books out and republished them as my own, I can't do that. It's about copying what's there, what's already in existence, either as a whole or a substantial part, rather than the idea itself. Because the idea can be expressed in many different ways. Copyright protects the work as it exists.
We always see, the word copyright being thrown around in the music industry and have done for decades, in terms of ownership. And we've seen some, in fact, I think we've done some podcasts previously on some of the, high profile court cases that have gone on. Of course, one of the most recent is Ed Sheeran. He seems to really be battered occasionally with others that are claiming that they got there first. You've ripped off mine or elements of mine. Now, don't get me wrong, I don't think it's necessarily possible for us to include a detailed analysis from a music law perspective and copyright in this podcast, but it's certainly something that we will go into over the course of the next few weeks, and I might introduce Michael Coyle to that as well. Okay, so just moving on, you mentioned about unregistered rights, registered rights, and IP as an umbrella. It sounds like an awful lot for and a minefield, might I add, for a business owner to have to sort of consider. But when you're just starting out, you haven't got much money, you're focusing on certain things. Would you consider that your intellectual property is something that you should be trying to protect and look after and wrap up in cotton wool in the early stages as soon as you've done? Is it something you need to factor in financially?
Yes, for two reasons.
Okay.
So you have certain intellectual property rights such as patents and registered designs where you need to be protecting your invention, for example. So let's stick to patents for ease. You need to be filing a patent application before you put your invention in the public domain. So actually, you need to be thinking about that way before you think about launching your
really
business.
Good point.
Otherwise, you're sort of shooting yourself in the foot. You can't then file the patent application if it's in the public domain. So that's really important. If you've got an invention or a new process that you know is new and doesn't exist out there, then seeking advice from the early stages is very, very important. From a more general everyday business trademark point of view, it's important that you secure your brand and you protect that before you pump loads of money into it.
Okay, so just pause there a moment, because there's one thing that you and I have both experienced over the years, and it saddens us every time. Again, I think we've touched on this in a previous podcast. There's a lot of due diligence that a business has to do in the early days from an IP perspective. That it's not that says that it's not just about you trying to protect your brand, it's about ensuring that you're not infringing on another.
Yeah, absolutely.
Now, we have had this several times with some really good quality businesses, and the business owners, they're sharp people, they're really switched on. They've got a hunger to see the business grow. One thing that they failed upon in the first instance is not to go and sit with someone like yourself, Ellis, or other professionals, where they can say, what are the sort of things I need to do? And we would immediately say, okay, well, let's just look at IP. Have you actually done a search to make sure that whatever it is that the name of your business, for example, has actually not already been done? The design of that particular product that you're immediately producing and you're going to be pushing out has not already been registered, has not already been done. So we focused on protecting yourself, but in actual fact, just to help to protect yourself, you also, in the early days, need to do searches to ensure that you're not infringing on others.
Yeah, absolutely, because the last thing you want to do is pump loads of money into production or marketing, and actually the rug gets pulled out from under your feet because someone else already exists. It's really important to make sure there is a space for you in the market with that brand name before you then start to pump loads of money into getting things
So
going.
without scaring the listeners that are thinking in this regard, what would happen, now let's just talk negative for a moment, what would happen if you didn't do that? And there's listeners out there going, crikey, hang on, I didn't do any of that. Well, if I now rang you up and you said, that's fine, we can do a search, because we offer different types of searches, don't we? But, we can do a search for them and we do uncover certain things. What's going to happen?
The worst case scenario is a complete rebrand. It's an absolute rebrand completely away from the brand you're currently using. There's obviously a lot in between that in terms of coexistence, reaching an agreement with the other party to work out who can do what, but ultimately that is going to halt your launch, halt the progress of your business, and also probably cost you more money. Trying to
get it done first so that it doesn't then cause that to be an issue is fine, and that would be for those listeners that are just about to start, thinking about this. But for those that maybe have already done, let's say, a year of trading, they're just ticking over, they're thinking about pushing themselves a bit further, they're now listening to this because they've got an interest in making sure that their IP is protected. There could be a gulp moment for them where they suddenly go, hang on, I didn't even think of that. Doing a load of searches on your Bings and your Googles and your Yahoos and your whatever it is that you've got out there as a search engine, as well as going through our databases to be able to search for registered marks and slogans and all sorts of stuff.
Yeah, it's important that if you are in that position, get in touch with us, let's do the search, let's see what's out there, and we'll take it from there. The longer you leave it, the more impact it will have on you, the more established you become, and the more likely that someone will be looking to... The more likely that someone will be looking to ask you to rebrand your business because you are established. There is that risk of confusion, risk of association.
Well, that was the point that I think I was just going to lead on to. So we're talking about why is it we're doing this? Because there could be a risk of confusion or association.
Yeah.
Now, that can damage a brand if you're really bad at what you do, and the other brand is really good and really established and has got this, really high quality assurance brand next, to its name, and now is being associated with you, who are... Not saying that you are, obviously, listeners, but there could be a brand that's out there that you're thinking, actually, we're not of the same quality. Now, that's not because you're bad at what you do, but because that's actually you're offering more affordable, goods or services to people. But they then say there's an association and therefore can damage their own brand because of that.
Yeah, and also it's just then two people in the market. If you're riding on the coattails of someone else, you are benefiting from their hard work.
Riding on the coattails.
That's not unique to me. That's
I like
a quote
it.
From a case, but you're then feeding off their hard work and success to fund and sort of build your own brand, and as you can probably imagine, that's not well received most of the time.
Of course it's not. Okay, right. So just passing comments then, from a business perspective, we've had this focus on intellectual property. We now understand why it's an umbrella term. There are lots of pockets of, within the IP, under the IP umbrella that you've really only just touched on, to be frank. There's a lot more to it than that. It can be a lot more complex. But if we say that there is a brand out there that has said, right, well, what I've done is I've got my design rights. I've got, because, I don't know, they've got some shape of some product they've got. I've got my design right. I've got my brand, but I've also got certain little sub-brands as well that I do as part of my products. I've protected them. I'm really, really pleased because I've managed to get that protection. But they've only protected them in the UK. What's the most common email or phone call that you get from people when they first ring up and they say, hi, I'd like to trademark my brand? Where is it they say?
Round the world. And can I file it just around the world?
Can I have a worldwide trademark? Now, I understand why there would be that confusion there, unless you get those that have got them in the UK. But one thing, certainly within all of the different points of IP, that umbrella, we need to be clear, must be clear to the listeners that there is no such thing as a worldwide X protection point, whether that be a patent, whether that be a trademark, whether that be, the design rights that you're protecting. You have to protect them in certain jurisdictions, otherwise there's a risk that it's not protected. Is that right?
Yeah, absolutely. So intellectual property rights differ quite dramatically around the world, particularly if you compare sort of us to the US, for example. Completely different. Still the same types of rights, but the process, the protection, completely different. So all intellectual property rights are territorial. They relate only to the territory in which they are registered. Now, copyright does extend across a number of jurisdictions, but we're getting into the nitty-gritty. Yep. Ultimately, you need to be protecting your trademark or your patent or your intellectual property in the countries in which you trade in and are looking to trade in. And keeping ahead of that curve is very important, because certain countries, it takes a lot longer than others. There is no one worldwide trademark, and if you've got a trademark in the UK, no, you can't stop that brand that's in Australia. You have to have protection in Australia to do that.
Really, really important that we get this point across.
Got walls around it. You can't get through with what you've got.
Okay.
So having that expansion of protection across those regions that's important to you is very important.
Brilliant. Okay, but I mean, that is one of the most useful things, I think, certainly from an IP perspective, and what our listeners are, hearing here today. You need to, because we have agents all around the world, and these agents are, just specialising in that particular area of IP in that country that they are based. We have that ability to get to all of these agents and say, can you assist our clients? They're actually a UK based company. I mean, they might not be, they might be an American. We've got a lot of of our clients that are around the world that need to protect in the UK, so they come to us. Similarly, we've got a lot of clients in the UK that need to protect in certain other areas of the world, but they use us to be able to get to those agents and give them that protection. Okay, so that really needs to be thought about, and cost-wise can be quite vast. So certainly if you've got a business model and you're working, you've got a business development plan together, you need to factor in these sorts of costs, because you'll be surprised how quickly it adds up. And I'm not talking about legal fees, I'm talking about filing fees.
Yeah.
It can be so much money, can't it?
It can.
Not everywhere.
And forecasting that is important in terms of where you're going and getting those applications in. There are routes in which we can file in multiple countries in one go, make it a bit more cost effective for you, but ultimately it is a pricey endeavour to get that widespread protection.
Brilliant. Okay, so I'm just going to move on just very briefly before we end this podcast, because there's been a lot of information thrown in on this one. Our listeners might be thinking to themselves, what happens when I've got a registered trademark or some design right, patent? I've got the protection there. You've done it. Well done, guys. High five. We've got the protection there. How do you ensure or police the protection that you have there? And how can you, if you've got lots of things in different parts of the world, how can you use? Is there an ability to keep that protection and look out for it?
Yeah, I think one of probably the most misconceptions is, I filed the trademark, that's it, job's done. No, you have to maintain your registration. It's up to you to take action to use it and continue to protect that
so just to pause there, that's another cost that you'd have to factor in, isn't it?
Yeah.
It's an important one, but it is a cost, because it might cost you for a cease and desist when you identified someone. It might cost. Well, how much is it that we charge?
£400, £500.
Right, so you might only pay £400-500, say 5 times a year, because you found 5 businesses that are trying to replicate what you've got protection on. But then, if it turns into something, it can be tens of thousands of pounds.
Yeah.
You may have to budget as a business if you're really trying to go out there and push. But anyway, sorry, carry on, right.
No, and it was even more so if you don't have that registered trademark. So you don't have that registered trademark in place, the costs to try and stop other people from entering your space and causing confusion is even more and even more complex. So we'll park that for another day. But the best way to maintain your trademarks, we'll take trademarks as an example.
Yeah, because it can be the same with the others.
Is by way of a watch service. So it's something that we offer. We will continuously watch all new applications as they are published.
Using a software,
and we provide you with a report basically highlighting those ones that are a risk.
Potential risk,
and that you may want to consider. So essentially we deliver the data to you, and then you can make the decision as to whether you feel you need to take action against these companies or not, whether it's important for your business to do so. Without that sort of service, you wouldn't have any idea what applications are going in, and you therefore wouldn't have the opportunity to stop them within the time frame that the application allows to file what's called an opposition. So that watch service means that you have the maximum time available to consider what you want to do about these businesses right at the outset of their application process. So it can be very, very cost effective. The cost does depend on how many marks you've got and whereabouts around the world they are.
Yep.
But to me, it's almost as vital as registering the trademark in the first place, because without it, you have no idea what's going on in the
You're
world
going
around
blind,
you.
yeah. You're almost wasting your money, because someone could continue
Essentially,
doing something like that without you knowing about it, because you're not keeping an eye on it.
Yeah, exactly.
So a watch service is a useful way of being able to monitor that, and you can offer that in the through the different intellectual property, rights
Yeah.
that you've acquired. Okay, well, that's useful for the listeners, I think, to appreciate that. And of course, if you want to get some pricing, just send us an email or pick up the phone and ask for Ellis. She'll set it all out and go through it with you. Ellis, this has been really, really good. I'm really grateful that we're getting back into the swing of our podcast, because I know that we used to have an awful lot of following. We then had some things that had gone on, and we ended up having trouble with technology and being able to get them optimized and everything. Plus, we've been very busy, and of course, ultimately, we do enjoy and look forward to doing these podcasts, but we're also trying to work at the same time and go through our matters. But thanks for listening. If you do need to get in touch, info@lawdit.co.uk. We can also do it through our website, www.lawdit.co.uk. And I have to say, I'm pleased that we're back.
Back in business.
Because I actually just found that really, really enjoyable, just listening to you, just explaining things that, of course, we do on a daily basis, but you break it down into something that is, just easily understood. So thank you very much for that. And we'll see you on the next one. Thanks all.
Thank you.